Our next speaker, Carolyn Fairless, is a partner with our Denver firm of Wheeler, Trigg O'Donnell. Carolyn started working as a computer analyst for IBM before moving over to her current path. She's listed in Best Lawyers for the legal and professional malpractice. She's a Colorado super lawyer for professional liability defense, and also among its top 25 women lawyers, Law Week Colorado's top women lawyers, Colorado Super Lawyers Rising Stars, I assume not starts, but stars, and Colorado Corporate Counsel Black Book for Business Litigation. Carolyn practices extensively in federal and state courts in Colorado and focuses her practice on professional liability, product liability, intellectual property, and commercial litigation. Carolyn's topic today, ethical issues surrounding settlement negotiations, is one that I think is going to be of great interest to our in-house counsel guests. Please welcome with me Carolyn Fairless.
Good afternoon. We spend a lot of time negotiating settlement agreements, and one of the things that I want to talk to you about today is how you can do that without stepping in it. So we're going to talk about three different topics that all relate to ethics and settlement negotiations. Number one, who can you speak to? Number two, what can you say? And number three, what terms can you request as part of a settlement? First, the scary stuff. In an ABA survey back in 2010, they surveyed various states that had about 1.3 million active lawyers, and there were 118,000 grievance complaints. For those of you who are statistics buffs, that means 1 out of every 11 lawyers in those states is getting grieved every year. Now, we all know a few lawyers who have a disproportionate number of those grievances, but we want to make sure that in negotiating settlements, you don't find yourself being one of those statistics. So first of all, who can you speak to? Who must you speak to? Under Rule 1.2, the client obviously has the final say in any settlement discussion. Now, you can get pre-approval as a lawyer to a settlement. You can go to your client and you can say, give me settlement authority within X range. And you can negotiate within that range without having to go back to your client every single time there's a step in the settlement negotiations. But you cannot enter into any sort of a settlement offer, obviously not enter into a final settlement unless the number that you are giving to the other side is clearly within the limits of your settlement authority, as well as the other terms of settlement. Otherwise, make sure that you've got specific client consent before putting a proposal out there that can be accepted by the other side. Now, who may you speak to in settlement negotiations? Under Rule 4.2, you as a lawyer are prohibited from speaking with a party who is represented by counsel in the case unless their counsel consents. Now, this can create problems because there may be times where you think that the lawyer has not conveyed a settlement offer to his or her client. And you are not permitted as a lawyer from going directly to the client and asking them if they received your settlement offer. So how do you get around that problem? There's an ethics opinion in 1995 which said you cannot use an intermediary to accomplish that goal of finding out whether the other side has found out about the settlement. The reason why is that you cannot do indirectly what the rules of professional conduct prohibit you from doing directly. So that put lawyers in a little bit of a quandary. And an ethics opinion in 1992 said, you simply cannot go to the other side and say, gosh, was that settlement offer communicated? Now, last year, a very helpful new ethics opinion came out, and that ethics opinion shed a lot of light on the subject of whether or not you can actually have your client go to the other side and make that inquiry. Now, clients obviously have the ability to discuss settlement or any other subject between themselves without having the lawyers present. They have that right. And you as a lawyer also have the obligation to represent your client competently, to represent your client diligently, and to communicate with your client. So there's a tension between advising your client about their right to speak directly to the other side and not indirectly violating the rule that prohibits contact with a represented party. So what the ethics opinion in 2011 said is it is entirely permissible for a lawyer to advise his or her client to communicate with the other side about settlement. And those communications that you have with your client can be substantive communications. You can discuss with them the issues to talk about with the other side. You can discuss with them the terms to request from the other side, the strategy for approaching the other side. Previously, there had been some states that had weighed in on this issue, and there was a little bit of a conflict as to whether or not the client had to come to you and ask you for that advice. And what the ABA ethics opinion says is we're not going to distinguish between clients who are sophisticated enough to ask you whether they can speak to the other side and clients who are simply too unsophisticated to ask that question. So the lawyer can initiate the conversation with the client and tell the client, look, we don't think that the other side is getting our settlement offers. Why don't you pick up the phone and call them? Here's what I think you ought to say. And that is permissible under this ethics opinion. Now, the lawyer does have to be careful of overreaching. And the ethics opinion defines 3 different ways in which lawyers, while advising their client about communications with the other side, can overreach. One is that you are asking the other side to enter into an enforceable agreement. The other is that you are asking the other side to divulge confidential or privileged communications. And the third way that you can overreach is by advising your client to obtain admissions against interest from the other side. So those are the areas in which you cannot go as a lawyer. So if you are going to ask your client to do any of those things, your client first has to tell the other side very clearly that they need to get counsel to represent them, and they're advised to get counsel to represent them before they do any of those things. If you do give your client a written settlement agreement to present to the other side, it also must conspicuously say on the written agreement that the other side is advised to get independent counsel to represent them before entering into it. But a very helpful opinion nonetheless. So let's assume that you know the other side's getting your offers, you're talking to their lawyer. What can you say in the context of settlement negotiations? Of course, settlement negotiations are a form of sanctioned dishonesty to a certain extent. If we were all honest in settlement negotiations, we'd pay a lot more money than our clients would like us to pay. So what can you do? What are the limits of the dishonesty in which you can engage as part of a settlement process? Under Rule 4.1, you are prohibited from making a false statement of material fact or law. The problem is that there's nothing in the rules of professional conduct that defines what a false statement of material fact or law is. The best guidance that we're given by the rules themselves is a comment that says that estimates of price or value or your intentions as to settlement are not material facts in the context of settlement negotiation. There have been some ethics opinions that have tried to shed some light on the subject. An ethics opinion in 2006 says that puffery is permissible in the context of settlement negotiations. However, the bottom line or the limits of your settlement authority are material facts, but your goals or your willingness to compromise are not. And it's not a clear line, but there have been some cases that have looked at that issue that do provide some guidance. There was a case where Texaco had been sued. Texaco entered into a settlement agreement with the plaintiff for $143,000. The plaintiff later found out that other similarly situated plaintiffs had gotten much more, $650,000, and made a claim against Texaco, claiming that they had made a material false statement by telling him that they would only pay $143,000. And the court said, no, that's not material. And so the court said, we're not going to let your claim go. There's another case that's reported where a plaintiff's lawyer told the insurance company for the defendant, my client cannot engage in, and I love this language, the slightest bit of physical exertion. And come to find out, the plaintiff could engage in physical exertion, and a claim was brought. And the court said, no, that's puffery. And what the court explained is that the insurance company could not reasonably have believed or relied on the statement as a statement of material fact. And so that was another case where the court said, no, just puffery, you don't have a claim for a violation of the rule. You also are not permitted to, you also are not required to disclose any weaknesses in your case. And there's a pretty remarkable ABA ethics opinion on this, and the fact pattern in that ethics opinion deals with disclosing that a claim is barred by the statute of limitations. And the ABA said that if you are the plaintiff's attorney, you do not need to disclose to the defense that your claim is time barred unless it's jurisdictional. The explanation that the ABA had is that for various reasons, the defense may not ever raise the statute of limitations, either because they just blow it, or because, for example, there's a strategic reason to do it. They want to bring a counterclaim that they can only bring in response to your affirmative claim. And so the ABA said, you do not have an affirmative obligation to turn over those bad facts. However, you also do not have to disclose, you also can, if you are the plaintiff's lawyer, you also are required to disclose if your client is dead. That is the one area which the ABA has said, okay, that's a material fact. If you've got a dead client, you have to tell the defendant about that. However, there is a line between failure to disclose and affirmative misrepresentation in this context. If somebody asks you, for example, what are the limits of insurance applicable to this claim? I believe there's actually a New York County Bar ethics opinion that says you can respond by saying, I cannot confirm or deny the limits of insurance, but you cannot give them false information. And a New York lawyer actually has been sanctioned for telling the plaintiff that the insurance limits were less than they really were. That is a fact, that's a material fact for settlement, and that did give rise to a grievance claim against the lawyer. So what if it's the judge who's asking you these questions, and you're sitting there in the courthouse at the court-ordered mediation, and the judge is asking you what your client's bottom line is? You cannot make a false statement of fact to the tribunal. So you can't tell the judge something that simply isn't true. The proper response is to tactfully, hopefully, decline to answer the judge's question and not to respond at all. So let's move on now to the terms you can request. You figured out who you can talk to, you're there in the middle of the negotiations. What can you ask for in the settlement? There have been different defendants who have said, well, gosh, we don't like this plaintiff's lawyer, and so we want to prevent him or her from bringing other claims against us in the future. And what the ethics opinions say, and what Rule 5.6 says, is that you cannot impermissibly restrict a lawyer's right to practice. And in fact, under Rule 5.6, you cannot even offer a provision that would restrict a lawyer's right to practice law. The most obvious example of that, according to a 1993 ABA ethics opinion, is to ask that the lawyer refrain from representing other clients in the future. That is impermissible. There's a state ethics opinion in Colorado that says that it is close but permissible to ask the plaintiff's lawyer to tell you that he or she has no present intention of filing similar cases. And what the Colorado ethics opinion said is the real test is, would an independent lawyer who is free from that settlement provision have a different ability to practice law than the lawyer that is entering into the settlement agreement on behalf of his or her client? And if you cannot say that they would have the same freedom, the same independent judgment in representing their clients, then that is an impermissible restriction on the right to practice. Okay, can you get the same result indirectly? Can you say to the other lawyer as part of the settlement, we will hire you in the future, therefore conflicting you out of representing future claimants? Again, the answer is no. The rules prevent you from doing indirectly what you cannot do directly under the rules of professional conduct. What about information learned during the course of the litigation? Can you prevent the lawyer either from disclosing that information or from using that information in the future? The answer to the first question is yes. Under Rule 1.6, lawyers have a duty of confidentiality that applies to any facts relating to the representation of their client. And if the client does not consent to the disclosure of those facts, the lawyer is precluded from disclosing them. So that makes perfect sense. If the client agrees as part of a settlement that their lawyer is precluded from disclosing information about the case, that is only what 1.6 requires a lawyer to do. So perfectly okay to require the lawyer not to disclose. However, requiring a lawyer not to use information that is in the lawyer's head that the lawyer has learned during the course of the case is an impermissible restriction on the right to practice law in violation of Rule 5.6. So that is impermissible. All right, well, so you can't require them to refrain from representing clients in the future. Can you at least ask them to identify other clients? No, unfortunately, unless those clients consent, that is information that the opposing counsel is precluded from providing to you under Rule 1.6. Can you require the return or destruction of documents? Yes, you can do that. If there is, however, a legal obligation on the other side to preserve the documents, then that will trump any request by you that they return or destroy the documents. Can you require an affidavit from the other party? Yes, with caveats. If you are asking for a truthful affidavit, that is perfectly permissible. But you cannot ask for an acceptable affidavit, because that suggests that the affidavit may or not be truthful and that you are offering an incentive to a witness in order to give testimony. You can also require, as part of a settlement, that they provide testimony to you at deposition or at trial, again, as long as that testimony is truthful testimony. Can you ask the plaintiff's lawyer to forego a fee? The jurisdictions vary on this, so you'll want to check your jurisdiction. There is a U.S. Supreme Court case that held that under a federal statute, the fee belonged to the client. So in that case, the court said the client could, as part of a settlement, waive the fee, which meant that that was a permissible requirement. Can you ask the plaintiff's lawyer to provide indemnity? The jurisdictions are pretty uniform in saying that no, this is financial assistance provided to a client that is unethical under Rule 1.8. So that's off limits. So in conclusion, I wanted to tell you to make sure everything is done ethically, within reason, of course. Thank you for your time.